On Thursday, the lawyers for the DUS tried to withdraw their case in a manner that would allow them to potentially refile the lawsuit in the future. However, Judge Deanna Johnson issued an order late Thursday saying the case is dismissed with prejudice, which typically means the same lawsuit cannot be refiled. Photo, Shelley Mays / The Tennessean, by photo. A flurry of activity Thursday in the legal case against a prestigious private school in Williamson County leaves the future of the lawsuit in doubt. In August, John and Jane Doe sued Brentwood Academy, alleging the school failed to prevent and appropriately respond to the repeated sexual assaults of John Doe. The DUS say John Doe was assaulted by fellow students in a locker room during the 2014-15 school year. Since filing, the case has garnered national attention. The DUS have switched attorneys and fiery battles have erupted in court. More, lawsuit, Brentwood Academy officials refused to report repeated rapes of 12-year-old boy. On Thursday afternoon, the lawyers for the DUS filed a motion to withdraw their case in a manner that would allow them to potentially refile the lawsuit in the future. We felt the court was forcing attorney-client protected information of the plaintiffs to be given to the defendants, so we dismissed without prejudice, said Burian Ledbetter, one of the DUS attorneys. However, a spokeswoman said Williamson County Circuit Court Judge Deanna Johnson issued an order late Thursday saying the case is dismissed with prejudice, which typically means the same lawsuit cannot be refiled. I just received word that Judge Johnson dismissed the Brentwood Academy case with prejudice from the bench. A written order should be forthcoming, said Barbara Peck, Director of Communications for the Supreme Court of Tennessee, in an email late Thursday. An order from the bench typically means a ruling made in the midst of a hearing. A spokeswoman for Brentwood Academy and one of the school's attorneys did not immediately respond to a request for comment. More, court unseals Brentwood Academy case after error made records secret. It is unclear how a judge can dismiss a case when attorneys are trying to withdraw that case. It all sounds very improbable that that's what happened. The plaintiff has the right to dismiss without prejudice, said Rob Harvey, a Nashville attorney who represents the Tennessean. There's almost no way a judge can interfere with that. I'm really puzzled what she did and on what basis. If that's what happened, it's highly unusual. Rules for Tennessee courts state someone who filed a lawsuit has the right to withdraw that lawsuit at essentially any moment before a jury begins to deliberate on the case. A party may voluntarily dismiss without prejudice, which means the case may be refiled as long as it's timely filed, Harvey said. It's unclear based on records explained to us how the judge converted the dismissal to with prejudice dismissal instead of without prejudice. Harvey added that he's never heard of a higher court upholding a judge's order to dismiss a case with prejudice issued after the plaintiff's attorney withdrew the case without prejudice. More, boy, parents accused in Brentwood Academy assault lawsuit deny wrongdoing.